Well, hi, everybody. Welcome back to the D.C. office of the Tenant Advocates webinar series, OTA A to Z. My name is Derek McGinty, and today we are going to talk about the E word, eviction. And while D.C. does have some of the strongest tenant protection laws anywhere in the country, those laws have recently been dramatically changed. Well, today, several things you ought to know about those new eviction laws. And by the way, this webinar and others in our series will be available at the OTA website. That's ota.dc.gov. Our guest today, Joel Cohn, the legislative director of the OTA. In past years, he's worked for the D.C. Council, where he helped write the laws that reformed rent control, and he investigated landlord abuse of city regulations. Joel, so good to have you.
It's a pleasure to be here.
All right, let's talk about this. The law changed a lot last year in 2018, but you say there are things that did not change.
Right.
What is still the same?
So very important for renters to keep in mind the ways the law has not changed, and that includes the district is a just cause jurisdiction. For DC, that means that there are the law specifies 10 valid bases for eviction, and the landlord cannot evict a tenant for any other reason. That's number one. Number two, there's no self-help eviction in the district, and that means that the landlord cannot evict a tenant without a court order and without the U.S. Marshal Service being present. And then thirdly, if the basis for the eviction is for non-payment of rent, the tenant always has the right to avoid the eviction entirely by paying the landlord everything that's due.
Wow. Okay, let's go back to your first point, which was that there are 10 things that 10 causes that are just for eviction in D.C. What are the top 2 or 3 of those?
So by far the most common cause for eviction is non-payment of rent. That's probably over 90% of evictions.
Wow. Okay.
The second most common basis is violation of an obligation of tenancy, and that could be the tenant is playing music too loudly or causing some sort of disturbance or nuisance to fellow tenants, et cetera. Thirdly, there's a criminal conviction that would not include some criminal allegation, but a court has determined that there's the guilt on the part of the tenant. Also, there's the landlord can recover for personal use in the occupancy either for himself, also for the personal use and occupancy of a contract purchaser. There are 2 temporary eviction measures for alterations to be made to the premises that can't safely be made while the unit is occupied by the tenant, and then also substantial rehabilitation, demolition, discontinuance of housing use, and there's a couple others.
A lot of complicated things going on there. Do you recommend that if a tenant is facing eviction or possible eviction that they hire a lawyer if they can?
Absolutely. So, and they don't necessarily need to hire a lawyer, but it's very important that they get legal assistance. Most eviction cases are heard with the landlord being represented by an attorney, and the tenant does not have any attorney and has not had legal help at all. So it's very important.
A serious disadvantage, I would imagine.
And it's yes. Tenants need to speak to a lawyer if there's any reason for the tenant to believe that there might be something amiss or some extenuating circumstance, even if it's about non-payment of rent. It could be that a lawyer, it's sort of their job to come up with legal claims, even where the tenant might not realize that there is a legal claim. So they always want to talk to a lawyer first.
Creative ways to keep you in your house. Let's talk about that law that changed in 2018. What are the big takeaways there?
So the big takeaways are number one, that the scheduling of the eviction has changed. Another key change is notice to the tenant, the notice that the tenant receives, and then also what happens to the property. So when the court issues a writ for eviction, the writ is live for 75 days, and that was true before the changes in the law and after. But under the old law, the U.S. Marshal Service didn't schedule the eviction until a day or a couple of days prior to the eviction date itself.
And would that be all the notice the tenant would get? Would be a 2-day situation?
Exactly. So the tenant would get a call from the landlord, I hope you're ready because you're going to be evicted tomorrow, essentially. And under the new law, The Marshal Service has to arrange for the eviction date, schedule the eviction with the landlord more than 21 days ahead of time, because the landlord is obligated by the new law to notify the tenant 21 days in advance of the specific scheduled eviction.
Does this have the effect of allowing a tenant to stay in their place much longer? I mean, if I haven't paid rent, let's say, as you say, that's 90% of the cases, and it's past the 1st of the month, it's past the 10th of the month, and I've got to get another 14 days before I can get out, who bears the brunt of that expense?
The landlord bears the brunt of the expense, but the landlords are in favor of the change of the law as well, because it saves them the expense of having to hire a crew, for instance. That's an expensive proposition. There's all sorts of problems in terms of what was happening under the old law, in terms of the property being dumped on the street, including safety challenges and the emotions running high and the potential for conflict between the tenant and the landlord, et cetera. So all signs are so far that the change in law is working well.
Have you seen a sign that you are not seeing as much of the scene where you see somebody's stuff out on the front lawn, that people are taking advantage of this notice to move and get out of the way so they don't end up in that situation where their possessions are being rifled through by the guy next door?
Yes. So the Marshal Service, we don't have a great deal of data as yet. But within 45 days of the change in the law in August of last year, the Marshal Service did a sort of an assessment, an update report, and it's certainly the street dump is not occurring. More tenants are vacating the units prior to the eviction date, which spares the government resources. They don't have to bother going through with the execution of the eviction, it's there are problems, but it appears to, the new law appears to its purposes.
Now, correct me if I'm wrong here, but isn't part of the new law that the landlord has to store your possessions for 7 days or something if you're not able to move them?
That's right. So besides the scheduling and the 21-day advance notice to the tenant, the third big change is what happens to the property. And the new law requires that the property be kept in the unit for a 7-day period, exclusive of Sundays and holidays. They have to allow the tenant to access the unit after the eviction and the change of the locks during that time period to collect their belongings and move them someplace else. And then after the expiration of that 7-day period, the tenant's personal belongings are deemed abandoned, and the landlord has the right at that point to dispose of the property in any lawful way.
So the landlord, again, pays the expense of storing this property for the tenant.
They're not collecting rent, but it's so.
No, I mean, but if I have to get a storage locker and move your stuff into it, they charge for those, don't they? No.
No, the law is that the property has to be maintained in the unit itself.
Oh,
so it's a
in the unit.
delay
Okay,
for the landlord in terms of renting the unit back up, but it's not an additional out-of-pocket expense.
I understand. All right, we actually have some questions from some audience members who have submitted these in advance, so we're going to talk about 3 or 4 of these. First one is, if you receive an eviction notice, what's the first thing you should do?
Okay, the first, if you get a summons to court, meaning that the court has not yet issued an eviction order, I think what you're asking is about what if you get a summons to the eviction court.
So the first thing you're going to get is a summons to court.
That's right, and with a court date on it. And what the tenant needs to keep in mind first and foremost is, 1, show up on time on the date listed on the summons. 2, often tenants don't show up. They have different reasons for not really paying attention to the notice or otherwise. And the court is going to issue a default judgment, and even a tenant who has legal rights is going to lose those legal rights because of the default. And then 2 is also if they show up on the date of the hearing, even if they haven't previously sought legal help, there are attorneys at the court, stationed at the court, legal service providers, and sometimes OTA, who can assist with providing advice and maybe work out a continuance so they can get representation or reach an accommodation with the landlord. And then the other important thing, though, is to seek legal help early, or,
Fair enough.
with
So-
OTA or one of the service providers.
So then, next question, how does this new eviction process work regarding a tenant who may be a senior citizen or has a disability? How does that work?
Well, there's no special process or special right for an elderly tenant or tenant with a disability. However, there is a provision in the new law that says the landlord has to notify an emergency contact, and an elderly tenant with a disability is going to be more likely to have an emergency contact filed with the housing provider about the eviction.
If there is no emergency contact, then what?
If there's no emergency contact, the process is exactly the same as for any other tenant.
Now, we've got a lot of rules in place designed to protect tenants and landlords in all this, but what happens if the property of a tenant is damaged or vandalized in the eviction process, including maybe when it had to be stored for 7 days?
Well, so the law doesn't address that, but there would be a potential claim by the tenant for basically a tort action in superior court by way of saying the landlord was somehow negligent or derelict in maintaining the property safely. They basically have some, not under the law, but under just the arrangement, a custodial responsibility to safeguard the property.
All right. I want to talk about the D.C. situation very specifically because we have seen the city's rental market change so much in the last few years. We all know rents are very high and people have struggled. Are there more evictions now, or are there fewer evictions now that so many well-to-do folks have moved into town?
I'm not sure I can explain the reason for it, but in just gathering some data prior to this podcast, it appears as though we're on track for fewer writs of eviction being ordered by the court. So we don't know whether that corresponds to a reduction in terms of the number of actions being filed, but we're on track for about a 40% decrease in terms of number of writs that are ordered.
That is not insignificant,
Right.
40%.
Right. And I'm saying that because that's based on the number of rapid response letters, and I should have said that the tenants under the new law, either as a legal obligation or because, in the case of the OTA, we're taking it upon ourselves to do it because the chief tenant advocate thinks it's a good idea. The tenant is getting notice from the Marshal Service about the scheduled date. They're getting the 21-day letter from the housing provider and then getting a rapid response letter from the Office of the Tenant Advocate. We've done about 2,500 so far in the fiscal year 2019, and we're about 3/4 of the way through. So extrapolating, that's about 3,300 that will happen in this fiscal year. 2 years ago in FY 2017, there were 5,500 writs that had been ordered.
So can
Again,
we-
not executed necessarily,
Sure.
but ordered.
Can we extrapolate that the rental market is more or less volatile because of what you're seeing there in terms of evictions?
Well, I think so. It's certainly based on the statistics, and we don't have the whole picture yet.
Sure.
There's certainly no reason to think that it's more volatile and possibly less volatile. Based on the 45-day report by the Marshal Service, both sides, tenant advocates and attorneys, and then housing providers as well, there appear to be few complaints about the new process.
Yeah, I was going to ask you, are there any other things you'd like to see changed in the future that might make this process fairer or easier to administer?
Well, two things. One is the emergency contact requirements falls on the day of the eviction, and it's a good thing because it puts the emergency contact in place to help with the property, the removal of the property. But if it were earlier in the process, and it may be being done anyway, but if it's legally required, it would be reassuring. If it was done earlier in the process, the emergency contact could be in a position to help avoid the eviction altogether, either by finding the resources to help the tenant pay off the rent in a non-payment case, and otherwise. So that would be an important change.
All right. Well, that's our time for today. Thank you to Joel Cohn for joining us to have the conversation on the ins and outs of eviction. We appreciate it. By the way, if you've got more questions for the OTA, you can ask them. Just go online, ota.dc.gov, or call us on the phone. The number is 202-719-6560, Monday through Friday, 8:45 a.m. to 4:45 p.m., or just stop in at 2000 14th Street Northwest, Monday through Thursday, 9 a.m. to 4 p.m. This has been OTA from A to Z. I'm Derek McGinty. We'll see you next time.